Viewers, I wish you a very happy new year. Our new year started rather late because the courts were all closed. Supreme Court and NCLAT, both of them opened on 6th of January. So we took about 2 weeks' time for the judgments to accumulate and then to select the judgments. Hope we have compiled a video and I do hope you're going to like the presentation. So with this, I take you over to the main part of the video.
Viewers, you can see guide to IBC.com website homepage on your screen. Now, our first topic is on section 7. So let us come to section 7. We are going to topic 78. Our basic interest in this particular case, Gagan, Tandon and others versus ILFS. Now, this particular case, you can see the details in the website. If I'm not wrong, this particular judgment of NCLAT was for, spanned about 87 pages. So this is a very interesting case. You should go through this. But in order to make it more understandable, let me take you to the slide share which I have prepared for you. On this particular topic, we are dealing with something called reverse CIRP. You will remember, for those who are new to this, you should look at the case. This was an invention, reverse CIRP term was an invention of NCLAT. And possibly the first case was Flat Buyers Association Winter Hill 77 versus Umang Realtek Private Limited. That was in 2019. The basic concept being when a corporate debtor, a developer, has multiple projects, and default happens with one or two projects, there is no point taking the entire organization into CIRP because that would be detrimental to the interest of the home buyers of other projects. So NCLAT came up with a view that CIRP should be restricted to the projects with which the default has occurred. So rest of the other projects will run as it is. CIRP will conform to only to those projects with which reverse CIRP, with which the default has occurred. Now, in this reverse CIRP, there have been a number of cases, but this is not an automatic process. the COC has to opt for it. Home buyers have to opt for it. There has to be circumstances needing for the court to resort to reverse CIRP. Now, in this particular case, the CD was a developer running about 26 projects in Uttar Pradesh, state of Haryana, Punjab, and state of Rajasthan. In Uttar Pradesh, they were developing a project called Sushant Golf City, which spanned, it was a mega project spanning in over 4,465 acres. Now, they had availed, prior to CIRP, they had availed finance from consortium of banks, and later they had availed finance from ILFS also. Now, default took place, and the court was in question as to whether CIRP will be pertaining to all the 26 projects or what should be the norm, because none of the parties had really sought for a reverse CIRP. So the court came up with a view that when the source of repayment as provided in the sanction letter and loan agreement confined to specific assets mortgaged and charged in the CIRP, only those assets or projects had to be resolved. In the sense, ILFS had given money to this particular corporate debtor, And they were fully aware of the money which the corporate debtor had availed from other banks. Now, in the mechanism for repayment, what was mentioned was the project in Uttar Pradesh, project in uh, three cities of Rajasthan, Ajmer, Jodhpur, and Jaipur. So the court was of the view that when the source of repayment as provided in the sanction letter, a loan agreement confined to specific assets mortgaged and charged, we are of the view that CIRP, only those assets or projects on which the charge was existed could be resolved. So this was a reverse CIRP by compulsion and taking care of the interest of the home buyers. So this is a very nice case. I'm not reading out all the headlines. Please go through the case for in-depth understanding. With this, we are moving to the next video. Viewers, you can see we are still in section 7. We'll come to topic 5, topic 15. And a very recent case of Honorable Supreme Court. The case being Elegna Cooperative Housing Commercial Society Limited versus Edelweiss. This is a very recent judgment pertaining to home buyers. It covers basically three aspects. One is regarding section 7. Another is regarding Locus, and we have covered that in section 62 and 4E, regulation 4E. Regulation 4E, if you'd like to recollect, let us see view index. 4E, you will find it in section 18, map to section 18, and 4E is with regard to handing over of possession. So in the conclusion, court had made some observations pertaining to handing over of the possession. But at the present moment, we are into section 7. So let us deal with section 7 first, and we'll come to section 62 later. In section 7, this particular case, topic 15, Elegna Cooperative Housing, a few vital questions or few vital confusions which still persist. Essentially on what is a financial debt and how a financial creditor and also a point of view of Locus has been addressed. So let me take you to, presently we are going to deal with section 7 only. So let me take you to the slide which I prepared for you. Now, the topic, as you can see, is question relating to feasibility and viability. Falls squarely within the domain of COC and cannot be examined at the threshold stage. Now, in this, the Supreme Court, this is, as I mentioned, this is again another judgment dealing with home buyers. Court observed that in theory, IBC presents an effective solution to the woes of home buyers, but in practice, home buyers are often gripped with anxiety, being caught between the developer on one hand and the institutional lenders on the other. And their interest is particularly vulnerable. But court also observed that a financial creditor should not resort to IBC. IBC is the last resort. Should not come to IBC for the purpose of recovery only. They have got other laws like SARFACI and others. IBC should be resorted to only for the purpose of resolution and to address the difficulties of the home buyers within the four boundaries of the law. Now, and the court held that the interests of home buyers are undoubtedly of paramount importance However, such interest has to be protected strictly within the legal framework. Now, in this quote, essentially, as you can see that I have mentioned as a reference, Vidarbha Industries Power Limited versus Axis Bank Limited. That was a Supreme Court judgment, in which despite there being a default, Supreme Court did not allow CIP process because the corporate debtor had had raised bills and invoices which were under consideration of the Supreme Court, and they were of the value much more than the debt in default or the entire debt. And often corporate debtors, they go to NCLT in Section 7 proceeding. They mention about the feasibility and viability of their and say that on the basis of that, they take reference of Vidarbha Industries judgment and object to the CIRP process. Now, in this particular judgment, Honorable Supreme Court made it very clear. It said that inquiry under Section 7(5)(a) is confined strictly to determination of debt and default, leaving no scope for equitable or exceptional circumstances. Means, in order to admit Section 7, what all the court has to see is whether there is a debt and default. And it also said, it very categorically said that Vidarbha Industries Power case was an exception, and that should not be taken as a rule. And court, in fact, you can see that Section 7 thus remains mandatory once the debt and default are established, with Vidarbha Industries operating only in exceptional circumstances. The exceptions don't make the rule. And court was of the view that the question relating to feasibility and viability falls squarely on the domain of COC. NCLT or NCLAT cannot possibly examine the viability matters at the threshold stage. The CD had defaulted. The default is squarely proved. So NCLAT was right, going by the dictum of IBC in admitting the CD to the corporate insolvency resolution process. Actually, NCLT did not accept, and NCLAT had set aside the judgment of NCLT, and they had put the company in CIRP process. And the company, of course, they approached Supreme Court, and Supreme Court said no. Supreme Court sided with NCLAT. So Supreme Court upheld the judgment of NCLAT and said that NCLAT was right. Section 62 thing, we'll take it up later. So with this, we move to the next case. I had mentioned about the Elegna case. Now, in Elegna case, the Honorable Supreme Court made some suggestions, which we have actually put it in Regulation 4E. Now, let us find out what does 4E say. 4E, Regulation 4E of CIRP regulation says that after obtaining the approval of the committee with not less than 66% of total votes, the resolution professional shall hand over the possession of the plot, apartment, or building, or any instrument agreed to be transferred under the real estate project and facilitate registration where the LOT has requested for the same and has performed his part under the agreement. That means it is a part of the responsibility of the resolution professional to hand over the possession and do the registration of the assets, maybe an apartment or whatever, in favor of the homeowner. With, of course, this requires approval of 66%, COC with 66% voting share. That means it takes, this is a resolution which comes under Section 28. However, for the sake of in the website, we have mapped this particular regulation with Section 18. Now, we come to the case. Now, the heading is, while the commercial wisdom of the Committee of Creditors is paramount and is not ordinarily amendable to judicial review, the width of powers vested in the COC carries with it corresponding duty of responsibility. So COC is vested, as we know, with COC's commercial wisdom is not justiciable. But that also carries a responsibility. It's but natural. So Honorable Supreme Court has reiterated that only. In the case of Elegna Cooperative Housing Society, Elegna Cooperative Housing and Commercial Society. Now, what is mostly important, I did not prepare a slide for this because this will be helpful for you. So, as I told you, that while the commercial wisdom of the Committee of Creditors is paramount and is not ordinarily amendable to judicial review, the width of powers of vested in the COC carries with it corresponding duty of responsibility. The information memorandum shall mandatorily disclose comprehensive and complete details of all LOTs. Now, the court has given some suggestions. Now, it is known that COC has immense responsibility. Now, how is that responsibility to be executed? With that respect, in the concluding part of the judgment, the Honorable Supreme Court has made some suggestions. So let us focus on the recommendations. What the Honorable Court has recommended is that the information memorandum shall mandatorily disclose comprehensive and complete details of all LOTs. Number 2 is where Committee of Creditors is upon due consideration, finds it not viable, approve handover possession in terms of Regulation 4E of the CIRP regulations. It shall mandatorily record cogent and specific reasons in writing for such decision. This is very important. It is not by whims. If you decide that you are not going to hand over possession, then in such case you have to put it down in writing as to why you have not decided to do so. And which can be challenged, of course, in court, but that is not, that can always be challenged by homeowners. But it is now a mandatory requirement. Number 3 is any recommendation for liquidation by Committee of Creditors shall be accompanied by a reasoned justification recorded in writing, evidencing proper application of mind and due consideration of all viable alternatives in consonance with the objective of the code. I had told you that while dealing with Section 7, that the court said that when you come to IBC, your sole purpose should be resolution, to give relief to the home buyers. So if we are deviating from there and recommending liquidation of the company, then in such case you have to put it in writing, and you have to show that you have applied your mind, and you have duly considered all the alternatives available with you, and then deciding to go for liquidation. And that has to be put in writing as well. So this is important. So that is why I shared this with you, and hope this particular case will have a long-standing effect like many other. This is a landmark judgment, I have no doubts about it. With this, I take you over to the next slide. The next case which we are going to deal with relates to Section 9 as well as Section 238A. Essentially, it's a matter of very interesting matter pertaining to a limitation and with regard to an operational debt. I would prefer to show you the case in 238A. You will find it identically the same case is repeated in section 9. So let me take you to 238A and let us come to topic 81, I suppose. Yes. This is the case of Heena Metal Private Limited versus Global Extrusions Private Limited. This judgment is exceptional because it deals with journal entries and limitation. Now, in this particular case, what happened was there were two, the corporate debtor and operational creditor. They were essentially involved in barter trade. The corporate debtor had a unit in Jamnagar and one unit in Mumbai. They had clubbed the entries after a certain, and this was permissive. They were maintaining accounts. Uh, uh, Jamnagar accounts was being maintained and Jamnagar was being maintained separately. Jamnagar was being maintained separately and Mumbai was being maintained separately. So let me take you to the slide share and hope for a better understanding. You can see the screen share. It says the topic says a journal entry cannot give a new date and a new life for the purposes of limitation to a transaction. It just shifts the entries from one account to another as it is, while maintaining the original character of the transactions. Now, in this particular case, what happened, as I told you, the companies, the operational creditor and the CD was having barter trade amongst themselves. The CD had unit in Jamnagar and Mumbai. So essentially, the dispute arose with the principal debt at Jamnagar unit, which was clubbed with Mumbai unit. The principal debt amount was 1,19,067, 1 crore 19,67,353. So, and this particular type of accounting, I mean, having Jamnagar separate and Mumbai separate, is permissible because the company was doing essentially barter system accounting. So this is acceptable as per the court. Now, basically, the problem arose with 4 journal entries that was made on 31st March 2020, in which the journal entries were dues of Jamnagar were shifted to Mumbai. Now, you will remember that this comes in the period of COVID-19 period. So automatically, COVID-19 period suo motu order affects it. And secondly, the court was of the view that a journal entry cannot give a new date and new life for the purpose of limitation. It just shifts the entries from one account to the another while maintaining the original character of the transaction. The first 4 entries for which the journal entry has been made on 31st March 2020 are time barred under the code, even if it is treated as an acknowledgement. Now, these debts pertain to prior to 2020. They were brought in 2020 to create an angle of limitation, because to extend the limitation period. So court was of the view that this is definitely a journal entry. An original transaction holds good, but you cannot change the dimension of the transaction or the aspect of the transaction through a journal entry. So this is absolutely a new topic, a new angle to handling of operational debt, and I hope you will find it interesting. With this, we move to the next slide. Viewers, you can see on your screen the dashboard for section 14, that is moratorium. So we have done enough of section 7 and section 9, which is, if in a day there are 4 judgments or 5 judgments, you can be rest assured that 60% of them are pertaining to section 7 or section 9, 8 or 9, mostly 9. So, but this is a Supreme Court case which I'm going to explain to you just now, show you just now. So let us come to topic 77, if I'm not wrong. Yes. This is a very recent case of Ansal Crown Heights Flat Buyers Association versus Anand Crown Infrabuild, etc., Supreme Court. This is a very recent judgment. And this is basically a National Consumer Forum judgment, which also takes into account the company went into CIRP. So this is both CIRP and as well as consumer complaint, both taken together. This is a very interesting case and covers a new side. So I would rather recommend that you should go through the judgment. So without wasting much time on this, I have prepared a slide for you, which will help you understand this better. So let me take you to the slide. Now the topic is, in the absence of prior and recent determination justifying disregard of corporate personality, the directors or promoters cannot be exposed to personal liability through execution. Now, in this particular case, what happened was Ansal Crown Heights Flat Buyers Association. You can well understand that this is a housing project. The project had not, as usual, it was not delivered on time. So they had lodged a complaint with National Consumer Grievance Redressal Forum. NCRDC, they had filed initially the case against both the corporate debtor as well as the directors. Now, NCRDC consciously said that no, the case should be with the corporate debtor. You do not have anything against the directors. So, with the specific direction of NCRDC, the Flat Buyers Association, that is the appellant, removed the name of the directors and proceeded with the case against the corporate debtor. And but what happened in between? The company went into CIRP, and NCRDC confirmed that since Section 14 moratorium is there, this cannot be, it is not possible for us. So that it should be, so the case is deferred sine die. So the Flat Buyers Association, they went and they wanted to file a case in which they wanted to file an execution case. And NCRDC had, prior to doing that, NCRDC had given an order asking the corporate debtor to deliver the flats, or if within a particular time, failing which they pay interest. And if they cannot deliver that, then they return the whole money with interest. And then given a time of about 6 months or so, 3 months or 6 months. So when moratorium started, NCRDC gave did not proceed any longer with the case because 238 is there, and also Section 14 moratorium is there. So they said that, sorry, we cannot proceed with the case. So the Flat Buyers Association went to NCRDC and they said that we rather go for execution of your decree against the directors of the company, which NCRDC rejected. Then they went to Supreme Court. And because they said that in the moratorium under Section 14 does not prohibits institution of suits and things against the company, corporate debtor, but not against personal, not against directors or personal guarantors, and etc. Supreme Court was of the view that was the view that did not agree with that, and stated that it is settled law that execution must strictly conform to the decree. The principle has been reiterated in catena of precedents. A decree cannot, by process of execution, be employed to shift or enlarge the liability so as to bind persons who are neither parties to the decree nor otherwise legally bound liable thereafter. So, in the original proceeding in NCRDC, by NCRDC had given a specific direction to amend the memo of parties, which was agreed by the Flat Buyers Association. They had amended, and since that order was not challenged, that order had become attained finality. So there was no pleading attributing to the personal role of the directors. No evidence led to establish that about individual culpability. No findings returned by regarding personal liability. The court was of the view that lifting of corporate veil is an exceptional measure to be resorted only upon clear finding that the corporate personality was abused fraudulently or for dishonest purposes. In the absence of prior reason determination justifying disregard of corporate personality, the directors and promoters cannot be exposed to personal liability through execution. And court upheld the judgment of NCRDC. They said that NCRDC committed no error of law or jurisdiction in declining to execute the order against persons who were admittedly not parties to the complaints. So this is rather what we normally study regarding Section 14. So this is a new way of thinking. Not exactly a new way, but this is not normal case law which we hear. And this is a very nice case law which I came across in Supreme Court. And so thought it would be good to share with you. So with this, we move to the next case. As you can see on your screen, the dashboard for Section 28. Section 28 deals with what? Approval of competitive creditors for certain actions. When you have to take approval of the committee. We are coming to topic number 2, which says that without stamp of final approval of COC, on the specific terms and conditions of interim finance cannot be read as compliance to the requirements outlined under Section 25, 28 of IBC and CRP Regulations 34B. This is the case of Religare Finvest Limited versus Resolve Support Services Private Limited. NCLAT matter, very recent judgment, goes without saying. This is essentially pertaining to an RP taking interim finance from its support service provider. And both NCLT and NCLAT strongly disapproved. They found that the action of the RP was deplorable. And they asked the RP and the funder, the support service, to refund a part of the fees which they had collected or the interim finance which they had arranged for. So please go through this judgment. It's a long judgment. But for the sake of this particular presentation, let me stop the screen share here and take you to the slide which I've prepared for you. Now, as I told you, to repeat once more, the topic is without the stamp of final approval by the COC on the specific terms and conditions of specific terms and conditions. Interim finance cannot be read as compliance of the requirements outlined in Section 25-28 of IBC and CIP Regulation 34B. Now, let us see what happened. In this particular case, what happened was the time gap between the first meeting and the second meeting was 15 months. Because in between, this was a case moved by operational creditor, and there was a uh, petition filed under Section 12A, which ultimately didn't go through. So there was a time gap of about 15 months in between, in which the RP, and there was no COC meeting also held during the 15 months period. RP did not uh, communicate with other COC members. He rather finalized the terms of availing interim finance from the support service provider. And he opted for a quantum of interim finance of 1 crore, with which carried interest of 15% per annum and also default interest. So the court held without the stamp and the approval of COC, you cannot possibly avail finance, which is creating a liability to the company. And you need specific approval. You will remember we had done a case like this earlier also in one of my videos, in which court said that without the stamp, without the permission from the COC, any money obtained as interim finance is not acceptable, doesn't constitute CIP cost. Any expenses made doesn't constitute CIP cost. So, and court was of the view that since CIP remained practically in abeyance for almost period of 2 years, that is 15 months, as I said, on account of filing of 12A, the claim of full fees by the RP was certainly not sustainable. Well, with a pinch of salt, I'm not an adjudicating authority, but I am by profession an insolvency professional. So I don't want to comment on this. It was a clear case of conflict of interest. Now, what the RP did was he availed from the support service provider one gentleman who was a managing director. His name was Vishal. He was acting as the legal counsel of the company. So while Vishal was the support service provider was providing finance, they were also deputing their person, Mr. Vishal, to handle legal case and charging FT fees. So there was definitely a conflict of interest. And RP also belonged to this. So there was a conflict of interest and they were related party transaction. Because Vishal belonged to support service provider. So court did not look at it in a very nice way. They were quite critical. In fact, NCLT held that the action of the RP was deplorable. And they said that there was a conflict of interest while the support service provider was providing finance to the corporate debtor, and on the other hand, keeping it into the corpus of the interim finance by way of fees of the RP and claiming legal fees. This is not permissible. And when there was nothing, and in between there was COVID period also, so all the laborers and people had left, so there was no activity in the company. And particularly the biggest mistake was the RP did not convene any COC meeting. So NCLT had imposed a fine of 65 lakhs, though there was adequate, NCLT was of the view that there is adequate justification for rationalizing the fees appropriated by RP for himself and legal professional. However, it would be reasonable to restrict this amount to 50 lakhs only. So 15 lakhs was somehow spared. But then, of course, this is a stigma for the RP as well as the support service provider. So with this, we stop the slide share and move to the next video.
Viewers, Guide to IBC is aimed at Insolvency Bankruptcy Code and various judgments, bringing it to not only to insolvency professionals, but to everyone. We have already shown some cases to you, and I do hope you like them. I'll be very happy if you'll like the video and subscribe to the channel, and as well as share it with your friends and relatives so that we become more and more popular and you become a part of Guide to IBC. I shouldn't call it revolution, but movement. Let me take you over to the next part of the video.
We are now in the dashboard of Section 30. And possibly this particular case is of last Friday. This is a Calcutta NCLT judgment, which was challenged in NCLAT. And NCLAT came up with a fantastic judgment. So, this is the case of Murlidhar Pandey versus Aditya Kumar. In this particular case, what happened was, while approving a resolution plan of the city, the resolution plan included assets or personal assets of directors as well as personal guarantors, which were mortgaged to the financial creditor. And these assets were included in the resolution plan and were sold. And resolution plan was approved. Now, you know, while in Section 14, moratorium, there's a specific saying that moratorium doesn't apply to the personal assets of the corporate guarantors and the directors. But in this particular case, what happened was the resolution plan was approved, and in which the assets of the directors as well as personal guarantors was included in the resolution plan and obviously was taken over by the SRA. So this is definitely a different type of this is a thing which we are hearing possibly for the first time. So this is no doubt a very interesting case and very interesting read. I would recommend to the viewers to go through the whatever is mentioned, the excerpts of the judgment mentioned in the website, uploaded in the website. But let me take you to the slide. Now, what does the main topic say? To keep the CD as a going concern, assets of directors and guarantors mortgaged to the financial creditor can be included in the resolution plan. The adjudicating authority, while approving the resolution plan as approved by the COC, has taken a conscious decision to include the properties of the suspended board of directors and guarantors of the CD for the purposes of smooth implementation of the plan. The properties of the suspended board of directors and guarantors of the corporate debtor have been mortgaged with the financial creditors of the corporate debtor. Furthermore, the notice under Section 13(2) of SARFAESI Act 2002 was issued not only to the corporate debtor, but also to the suspended board of directors and guarantors as well. And it was mentioned, their guarantee was mentioned. Now, the court took into view that the entire plant and the factory of the corporate debtor was being established and was being established on this land, which was being sought to be transferred to SRA. Because if the land is not there, where to the plant and machinery in the factory, where to establish it? And since this was already mortgaged, so why not? The company had also created a lease in the name of somebody. And NCLT took it into account and cancelled the lease. There was a question, it was vehemently objected. And it was stated that this is beyond the jurisdiction of NCLT. This comes within the jurisdiction of civil court, which obviously NCLT and NCLAT did not agree. This matter is concerning a resolution, and this is an essential part of resolution process. So adjudicating authority thought it was correct to include this in the resolution plan, even pertaining to assets which were leased. The cancellation of the lease, because those were all sham lease, and which was detrimental to the resolution process and which was detrimental to keep the company as a going concern. So they were allowed by the lease was cancelled by the adjudicating authority. And best part was NCLT Calcutta this was not the first judgment. They had issued a judgment like this on 4th of July 2022, and which became final and binding, as no appeal was lodged either in NCLAT or Supreme Court. So under the circumstances, court was following its order, which remained unchallenged. So this had become a res integra matter. So NCLAT upheld the matter, and this is what I say a Hatke judgment. And this is very important. We should keep it in view. So with this, we move to the next topic. So we have done one case in section 30. Let us come to section 31. We are in the dashboard of section 31. You can see topic 124, which says that the approval of resolution plan does not ipso facto discharge a security provider of her or his liabilities under the contract of security. This is Electrosteel Casting Limited versus UV Asset Reconstruction Company Limited. This is a Supreme Court judgment of very recent, I suppose 6th or 7th of January. Let us come to the details. There are two judgments. There are two judgments of Supreme Court which have come together. This is one of them. Now, this is pertaining to, it's a good read. See, it deals with security interest given by ESL, that is Electrosteel Limited. As we know that Electrosteel Casting Limited went in for CIRP, and they had a resolution. So I would request all the viewers to please go through the excerpts of the case, which I think you will find it interesting. So let me stop the screen share here and take you to the main judgment. The slide which I prepared for you. Before I start on discussing about the case, I would like you to remember the judgment of Supreme Court in Lalit Kumar Jain versus Union of India, which said what? That a resolution plan ipso facto does not absolve the liability of a personal guarantor. Remember? So this case is to a great extent similar, though it doesn't deal with personal guarantors, but it's in the same line. It's in the same line. Now, in this, what happened was ESL Limited had availed funding from Shrey, and even Electrosteel Casting Limited had also obtained funding from Shrey, and Electrosteel Limited, ESL, had provided corporate guarantee. Now, the debts were, while in the resolution plan, the liabilities payable, the liabilities payable to creditors were put in two groups. One was active, another was semi-active or something like that. Now, in this, the company ESL Limited allotted 761.92 crores shares. It was reduced from rupees 10 each to rupees 20 paise fully paid up. So clause 3.28b of resolution plan envisages that financial creditors were to hold shares worth 152.38 crores comprising of 7.60% of equity of ESL. So, and thus, 7,619 crores under the resolution plan were to receive shares in, the total value of 152 and shareholder debts worth unsustainable debt. They had taken up segregated debts into sustainable debts and unsustainable debts. For unsustainable debts amounting to 7,619.24 crores, they were to receive shares worth 152.38 crores. Now, Shrey, which initially got about X amount of shares of 10 each and was reduced to face value to 67 lakh shares, found that they were not, they didn't get the objected. They found that the number of shares allotted to them were less. So they approached. And Shrey had assigned the debt to UV Asset Reconstruction Company. The Supreme Court in this case held the resolution plan unequivocally provides that the right against the third party, including security provider, existing promoter in relation to any portion of unsustainable debt secured or guaranteed by such third parties will not be extinguished. It's the same like Lalit Jain judgment. A resolution plan is a resolution plan. The corporate debtor goes back in clean slate. But with respect to the guarantors and others, the security or the guarantee, the liability continues. So, Supreme Court held that it was well settled that an approval of resolution plan does not ipso facto discharge a security provider of her or his liabilities under the contract of security. So it's the same. What we heard in the case of Lalit Kumar Jain and Union of India, Lalit Kumar Jain versus Union of India, that pertained to personal guarantors. And this is with third party, security providers. So it's the same. It's the repetition of the same thing. But this is important. It's a revision for us. And you should take this into account. So with this, we move to next case, which possibly, it will be of section 62. Yeah, thank you. Let's move to the next case. Viewers, we are returning back to Elegna judgment. And as I told you, we'll go to section 62. So in section 62, this is yes, topic number 10. As I mentioned to you, Elegna cooperative judgment is a Supreme Court judgment. These are three aspects rather. Section 7, Section 62, and Regulation 4E. Regulation 4E is a small matter, you can go through it. But let us now deal with Section 62, which essentially matter pertaining to Locus. Now, in this particular case, what happened was the society of homeowners, they made a challenge. And NCLAT held that they had no locus whatsoever. Being a society, because society is not a corporate entity. It's not a person. It cannot be treated as a corporate entity, and it cannot be held that they have any locus pertaining to this particular matter. So the matter went to Supreme Court. It's a very interesting read, and I would recommend all the viewers to please go through the excerpts of this particular thing, this particular section, this particular judgment, and this particular section 62 aspect. So let me stop the screen share here and take you to the slide which I prepared for this. Now, the Supreme Court, this reference is, as I told you, the entire concept of CIRP and locus changed with the judgment in the case of Glass Trust Company LLC versus Baiju Ravindran. Now, in this particular case, also refers to Glass Trust. The main heading says that a party must demonstrate legally cognizable prejudice and cannot be a complete stranger to the insolvency process. Now, court reiterated the judgment of Glass Trust case and said that while there is no rigid requirement restricting the right to appeal only to the applicant creditor and the corporate debtor, such latitude applies when proceedings are in rem and post admission to CIRP. But however, a party must demonstrate legally cognizable prejudice and cannot be a complete stranger to the insolvency process. Now, home buyers are home buyers, to them, their financial creditors. But what about a society? So how can one say that a prejudice has taken place as far as the society is concerned? The Supreme Court was absolutely right. The Supreme Court held that society is a distinct juristic entity separate from its member. And unless it has itself advanced funds, executed allotment agreements, or received allotment, it cannot claim a financial creditor status. Come to think of it, home buyer societies or associations, they are basically ordinary for maintenance and management of common area. So even if the office and thus the office bearers of the association or the society, it cannot be treated as having locus to challenge a Section 7 matter, because they are not. And when there is a specific statute, the court reiterated to the mechanism mentioned in Section 21, subsection 6A, read with Regulation 16A, which applies to appointment of authorized representative. So there is a system already in place that you can appoint an authorized representative once a CIP is admitted. Then why bring in society in between, which doesn't have any locus? And court also mentioned, took a view that when you file a Section 7, if homeowners are filing Section 7 petition, you file it either individually or jointly, and with prescribed number of allotees, as mentioned, that it should not be less, minimum 100 or 10% as mentioned in Section 7. But you don't file such petition through authorized representative, much less through a non-party like housing society, which is mentioned, which is basically created for the purpose of maintaining the common areas. So a court held that NCLAT was absolutely justified in rejecting the society's intervention application, and no prejudice was caused to the home buyers by such rejection. So this is a very nice judgment. This is a very nice judgment, in fact. So with this, we take you to the next case. Because we have done many cases in corporate insolvency. So let us come to individual and partnership and come to Section 95. We are on the dashboard of Section 95. We have a very recent case that has happened. The topic is, in the event of income tax return of the personal guarantor not filed, the application cannot be held to be defective. The case is Siemens Financial Services Private Limited versus Ravi Kumar Jain. This is an NCLAT NCLAT judgment. The excerpt of the judgment is here. So basically, what NCLAT wanted to find that whether the Siemens Financial Services had invoked the personal guarantee, whether petition filed under 95 was complete and maintainable, whether auction of alleged property is null and void under 96 of IBC. The above factors were considered. So I would recommend that you go through the judgment, excerpts of the judgment, and let me take you to, for your understanding, quick understanding of the subject of the case, let me take you to the slide which I prepared for you. Now, in this particular case, what is mentioned that in the event income tax return of the personal guarantor not filed, the application cannot be held effective. In this case, what happened was the resolution professional who had submitted the report had mentioned about the legal notice dated 7/12/2020 and the demand notice of 14/12/2020. Chandigarh bench of NCLT uh, declined to accept the 95 petition and said that the guarantee has not been properly invoked. Now, NCLAT went into the matter. They checked that the guarantee deed contemplated issuance of demand by written communication by the lessor to the guarantor. So it also mentioned the notice that the corporate debtor had committed default in repayment of lease rentals. With reference to notice number 2, Ravi Kumar Jain, that is uh, the respondent here, was mentioned that he undertook to repay all amounts. The statement clearly indicated that in the said notice, it was a written communication intimating that outstanding amount of 9,97,097 lakhs 31,150 was due and payable, and they demanded payment. And adjudicating authority, without having not averted to the notice, legal notice dated 7/12/2020, concluded that demand notice was not served. Whereas the guarantee did contemplated a written communication. This was very much a written communication. So NCLAT was of the view that adjudicating authority had made a patent error, definitely an error, and the order was not sustainable. But then the corporate and then the personal guarantor, the lawyer of the personal guarantor, mentioned that the income tax return of Ravi Kumar Jain had not been submitted. This was a legal flaw which was mandated under the rule and the regulation. And even the 99 report did not mention the income tax return of the personal guarantor. The court held that this is a hyper-technical matter. The basic question was whether there is a failure to pay the guarantee. There was a guarantee was invoked, and the personal guarantor did not pay the guaranteed amount. So 95 was maintainable. Whether the income tax return was not filed doesn't make the application defective by any means. So the order of NCLT Chandigarh was set aside, was held to be unsustainable and was set aside. So with this, we have a new case in bankruptcy. So I take you over to the bankruptcy matter. Viewers, you can see section 159 of Insolvency Bankruptcy Code, which pertains to after acquired property of bankrupt. Now, why we have selected this case has just come out very recently. You know, the personal insolvency is new, and we had quite a number of cases regarding insolvency. Now, bankruptcy, the insolvency part, has already a number of people have gone through. So now the bankruptcy is gradually. It's not that the repayment plan of everybody has been approved. So a number of cases of bankruptcy is going to happen. A number of such matters will go to NCLAT and Supreme Court. So we have got one. This is a very informative judgment. So section 159 deals with after acquired property of bankrupt. Means what? The property which is acquired after the order of bankruptcy. Now, the law says bankruptcy trustee shall be entitled to claim the estate of the bankrupt any after acquired property by giving notice to the bank. And notice under subsection 1 shall not be served in respect of exclusive assets. By any property which is acquired or devolves upon the bankrupt after a discharge order passed under section 138. Notice under subsection 2, 3 says notice under subsection shall be given within 15 days from the date on which the acquisition or devolution of after acquired property comes to the knowledge of the bankruptcy trustee. And then so on and so forth. In the judgment, let me take you to the judgment. I would strongly recommend that you go through the section. Let me take you to the judgment. This is the judgment of Subhash Chandra Mishra, personal guarantor versus Sunil Kumar, bankrupt trustee. Any property acquired subsequent to the bankruptcy order shall not automatically become a part of the bankruptcy estate, which is clear from section 159. We have gone through a part of section 159. So it doesn't, before bankruptcy order, whatever asset is there, it is automatically bankruptcy trust. It comes as a bankruptcy trust, bankruptcy estate, and bankruptcy trustee takes over the asset. But after acquired, does not automatically become. He has to issue a notice within 15 days of coming to notice it. It cannot be an asset which is excluded debt. So those are the factors which have to be looked into. So this case is particularly important because this gives you a background of many of the sections. It will help you understand the bankruptcy process. This defines section 128, section 136, section 154, 155, estate of bankrupt, and after acquired property of bankrupt. The entire case is mentioned. And this is an important 79 for what is an excluded asset. And so this judgment should serve as a dictionary for us. So should serve as a dictionary for us, and I would recommend all my viewers to go through this case. But in order for this particular presentation, I have prepared a slide as usual, and let me stop the screen share here and share the slide with you. As mentioned, any property acquired subsequent to the bankruptcy order shall not automatically become a part of bankruptcy estate, which is clear from section 159. So in this particular case, bankruptcy order was passed on 6/11/2004. Bankruptcy trustee was appointed on the same date. And by virtue of section 128, the bank estate of the bankrupt vested in the bankruptcy trustee. Section 154 provides that the asset of the bankrupt shall vest in bankruptcy trustee immediately from the date of appointment. And section 155, subsection 1 provides that the estate of the bankrupt includes all property belonging or vested in the bankrupt at the bankruptcy commencement date. So in this case, what happened was the bankruptcy trustee had frozen all the bank accounts. So the bankrupt was of the view that bank accounts, personal accounts of the bankrupt was supposed to be an excluded asset. But after going through section 79, it was court opined that no, bank account is definitely not a part of that. It's a house, personal jewelry, a car. House also has a definition. I mean, depending on the location, the value of the house. I mean, there are things like that. So, amount lying in bank of the appellant was clearly property of the appellant, which amount shall stand vested in the bankruptcy trustee on passing of the bankruptcy order. And bankruptcy trustee was fully justified in instituting a debit freeze in the account. And the submission of the bankrupt that the amount is an excluded asset was not accepted. And the court opined, but there was some 10,000 was deposited thrice. And there was some income also earned. So court was of the view that any property acquired after bankruptcy order does not automatically become part of the bankruptcy estate, which is clear from section 159. The bankruptcy trustee has to follow certain procedure. And if such procedure well, it is not a law is not never one-sided. So if a bankruptcy trustee gives a notice, a bankrupt has every right to object because he has a right to live. So 159 gives a kind of a breathing space for the bankrupt. And that is why this is important. So as I say, this is an important case. You should go through it. And I hope this will, as a starting point in the matter of bankruptcy, this will give you a very good idea.
Viewers, we have come to the close of our presentation for this week. Not this week, I would say rather third week of up to third week of January. I don't think it will be possible to make another video during January because we are already on the third week, almost on the fourth week. So let us see if towards the end of January we can do another video. Otherwise, definitely by beginning of February you'll get one. So with this, goodbye to all of you and hope to see you again very soon. Thank you.